It's an interesting panel because we have an interesting assemblage. Including myself, we have 2 graduates of Georgetown University Law Center, 5 lawyers, 3 Army veterans, 4 members of Congress, 1 senator and 3 members from the House, 3 Democrats, 1 Republican, 1 independent, and people from Massachusetts, Wisconsin, Kentucky, California, and Vermont. And we're going to be talking about copyright. When I was a law student at Georgetown Law Center, having first become acquainted with cable television when I worked as a pole lineman for all-band TV cable in Olean, New York in 1960, that was owned by a guy by the name of Bill Daniels, who's become a legend in this business, and another distinguished St. Bonaventure alumni in the form of John Summers, the Executive Vice President of the National Association of Broadcasters, is here in the audience. I became familiar with cable in a rural environment of upstate New York, and I recognized, having been born and raised in Washington, D.C., the capital of the nation, where we didn't have cable and don't have it today, I recognized that it was going to be something to be reckoned with as an industry, because it had a dynamic impact on that small rural community where people were essentially able to get more television entertainment than I had ever seen before in my life, with pictures that were just about perfect. And so I decided then and there that I was going to latch my little leader onto the industry as best I could. And in law school, I started writing articles, and one of the articles I wrote was Cable and Copyright, the Coming Crisis. That was 1962. Senator Leahy was a bit ahead of me in school. I couldn't get it published except in trade journals. I think if you took that early article, 1962, and if you took out the word coming and you put in constant, and you added a couple of paragraphs here and there, and you changed some of the dates, so it became Cable and Copyright, the Constant Crisis, I would have a lot of pertinence to some of the things that we're talking about today. I think one of the reasons for that is because in a free society such as ours, the flow and the free flow of information and intellectual product is so important and so much a part of the fabric of our society that it takes on a dimension that is different to contend with than in other societies that are more closed or not as far advanced. The total issue of copyright is really one of the protection of some of our fundamental industry, intellectual product. One thing that America as a country and as a capitalist country does, and does very well, is intellectualize. We are thinkers, and we are creators. And in this business, we are transporters of entertainment and information and knowledge. And in an information society, that translates to power, and power is important. The issues are extraordinarily intricate. And they are so intricate that history will reflect that the one of the initial interests of the founding fathers of our country, recognizing what they were doing, was the protection of intellectual property and the creation of the Library of Congress and the concept of copyright, carrying that over from the British system. The Copyright Act was created or written originally, the first revision took place in the early 19th century, when the real evolution of our society was taking place, and the next revisions weren't for over 70 years later, 60 years later. It's a very difficult, intricate, and confusing issue in copyright. But the people who are here this morning as members of this panel are all adequately capable of addressing the issue because of their experiences with it in Congress, and because of the fact that they recognize that it intertwines among all of our society today. It's a difficult panel to to present. It's a difficult subject to present because we don't have anything specific to talk about. We know that we had the Copyright Act, and we know that the Copyright Act created a tribunal. And we know that the tribunal itself has created problems for us, and it's created problems for others. It does not appear to be a highly workable alignment for the benefit of the participants in the industry. We're concerned about it, and there's considerable effort taking place to have revisions made in the way the tribunal is structured and the way that the dollars are counted, if you will, and distributed. We have to recognize that we are now talking about what is at minimum a $100 million a year pool. So we're not talking about a small Calcutta. And it is a pool that will get larger and become a little more difficult to administer. I don't know how to ask the questions of each one of the members here, but I would like to ask them if they would individually, starting down the line from Congressman Moorhead, who I will introduce from California. Congressman Moorhead is a Republican from California. Next to him is the Honorable Romano Mazzoli, is a member of the House of Representatives from Kentucky. Next to him is the Honorable Robert Kastenmeier from Wisconsin. Next to him is the Honorable Patrick Leahy, Senator from Vermont. I'm not going to dwell too much on their backgrounds. I think these gentlemen are pretty well known in our industry, and their backgrounds can speak for themselves. But I would like to ask them, for each of them, if you would, just to make a comment, if you would, on what you see existing in the realm of copyright and what you might think Congress would be looking to take some action in the near term.
Doesn't matter.